Give Frank another minute here.
Why do you think that thoughts about it? Why did I put the check on that wall? Why did I feel that way? I shouldn't feel like that.
We're waiting for them to come back in from the executive session, waiting for Frank Ledwin to sit down. I guess they're going to restart the meeting.
Okay, we're going to resume the meeting now. We've come back from the executive session, and we've worked on the two contractual matters with the Pavlicek and Klinger Field. Dan will be sending a letter to Pavlicek that we discussed, and we'll be working with the Hoff-Richter property next door, and we'll be talking about making an offer with them in the future. When it comes to the personnel matter, we're going to have to just the supervisors and staff, we have a policy, and we're just going to have to follow the policy.
What's the policy?
The policy is what was passed a year and a half ago that Tom wrote up, and I don't know if it's on the website or not. There's 3 pages full of it.
Well, I mean, as far as I can remember, the policy was for anybody not to be demeaning to the workers of the in-house, correct?
There was a lot
of it.
There's a lot more to it than that.
Oh, well, then give me the specifics. What were the policy? Give me a little.
You can go ahead. Don will send it to you if you can request it. You can
I need to
request
write
it.
the note for that too, or?
No. Do we have that on the website?
I don't know, you can be.
I think we have it on the website. If we don't, we'll get it put on the
Well, I mean, then
website.
what was the meeting about the policy? Was to reiterate the policy, or what was the meeting about?
Generally,
So in other words, you're saying that somebody's violating the policy?
correct.
We're not going to go into the details of it because it is a personnel matter, and we just want the supervisors and staff to follow the policy. That's all. That's all I'm going to say on it right now. So we're going to move into the next. In Resolution 96-2014, set a date and time for revisiting an ordinance for the fine and penalty for deposits of snow placed on the streets and roads. Now, we do have next month in June, we have the ordinance hearing. So I think in July, that'll give plenty of time to go through what we discussed earlier, John and Dan, with getting everything back on that ordinance, correct? So let's set it for July, the 15 minutes before the meeting in July then.
Some said an hour.
No, this is for the snow
Oh,
removal.
okay, yeah, that's it.
In June, we have an hour before, Tom, for the conditional use for the station down here, the gas station. Is that, everybody agree with that?
Yeah.
Okay. Now, motion number 97-2014, consider the Board of Supervisors minutes from the regular monthly meeting of Monday, April 7th, 2014. Do I have a motion?
I'll make that motion.
It's moved. Do I have a second?
I'll second it.
All in favor, say aye. Aye. Okay, number 98-2014, consider the general fund invoices from April 1st through April 30th of 2014. Do I have a motion?
I'll make that motion.
It's been moved. Do I have a second?
Second.
All in favor, say aye. Aye. Okay, it's so moved. Now, under Board of Supervisors, new business, one opposed. Did you catch that, Carol, 4 and 1?
Thank you.
Okay, is there any new business that we have to discuss?
Yes, I have one item to bring up about the Puchany property. I don't know where we're at with the attorneys and the insurance company, the attorneys working that. We have the right through the second-class township code in a dangerous structure. And I think separate from what the attorneys do with from our insurance carrier and the ongoing battles or obstructions that Puchany's attorney throws up, I think we need to adopt a resolution offering what's the term? Well, Dawn's getting that for me. What's the term in there for, it's not a resolution. by ordinance. We have to, instead of adhering for an ordinance, to just declare it a dangerous structure, and if the applicant or the property owner appears before us, fine. If he doesn't, then we still can take action on it. And I don't mean tearing it down, I'm talking about just taking the action to go through the motion. We're not getting anywhere with our attorneys. We've been trying for months and months. And the code says,
What part of the code?
jeez, I just lost it. It says, the Board of Supervisors may, by ordinance, require the owner to remove any nuisance or dangerous structure on public or private grounds after notice to the owner to do so. In the 1533. In the owner's default, the Board of Supervisors may remove that nuisance or structure and collect the cost of the removal, together with any penalties imposed by the ordinance. And our ordinance also says that our zoning officer or other legally designated township personnel may apply to any court of competent jurisdiction for a search warrant or other legal process for the purpose of securing entry to any premise if the owner, tenant, or occupant shall refuse to grant entry. That's what we've been dealing with for the last 10 years with that guy. And I'd say we should stop right now and set a hearing for the ordinance to remove that structure, and also direct our zoning officer to apply to the district justice for right of entry, which would help bolster our case.
That's
Didn't we already do that?
where we were, Tom, is that making sure that, we've actually prepared a search warrant to get into the house. I mean, that's the whole thing, in order to have the hearing on dangerous structure, to gain access to the home. So I think we even said, Bruce is not licensed to make that application to the magistrate, I believe. So that was one dilemma. And Sean,
It says right here that we're any designated township personnel, so we'll designate you then, and we want to get in front of that district justice.
I think,
I'm not claiming any contacts with him. I would go there just like any other board member will, sit in front of that board and tell them why we need to get in there.
but I think under the law, only the police or the zoning officer have the ability to get search warrants.
But didn't we already say that the police are deemed assistants?
Can you speak up, please?
Yeah, I
The
got
police
out.
are actually,
Well, talk louder.
I handle the zoning officers. for us.
And Tom's right, this is the route to go. It's, obviously we have to work out the kinks with the insurance counsel, with Steve, I know has.
Let him come with us. I'm not advocating of taking the wrecking ball out there tomorrow.
I understand.
We got to get in front of the district justice.
Get inside.
He'll give us a court order to get, or a search warrant to get inside.
Yeah, I understand, and Bruce had to have, for Bruce, even though the township code says he can do it, he has to hold certain licenses in order to get the search warrant. As to the chief, I'm not sure if, I know you have that power to do that.
Yeah, I think Bruce is working on it with the state to get that agreement.
No, we're not going to wait for him to.
I understand, that was the issue generally.
You have the power to do it.
We'll have an officer meet with them. I believe we probably have the ability to assist the zoning department, but we could have an officer assigned to meet with Bruce and see if he can work.
Tomorrow.
Okay.
Then the next thing is, I'm not advocating to go take the wrecking ball there, but if we if we can get inside there and have our guy look at that, and when I say us get inside, I mean our engineer to look at it. If he says it is sound, then I agree, we got to go back to the way the zoning board was looking at it, and maybe forcing compliance with the building maintenance code. But right now, we're 90% sure it has to be torn down. One we know for sure has to be torn down. I'm talking about the second one. And we're no further ahead than we were last month or the month before. 10 years ago, it's the same thing. It's Puchany and his attorney.
The step was, and I don't even know if you can say this.
Speak up.
If someone from.
We can't hear.
I'm worried about your microphone. Someone from your office was going to help Bruce and one of the Cecil police officers write up something.
The search warrant itself is really no different, Sean, than any other search warrant. No, I'm sorry, my mic is down too. There's not much different. We did write one up today and send it to Bruce for you guys to take a look at to see if that would suffice. We typically don't deal in the search warrant world, that's your world. But we have a version, an affidavit of probable cause prepared for you guys to take a look at. just so maybe when your officer talks to Bruce, they can check our work that we provided and see if that will suffice.
Yeah, we'll get it done. And the thing is, I know it is different than a search warrant the police department does. I did discuss that with Bruce at the date before. So with his assistance with the officer, we'll get this done as soon as possible. But for his sake, he has been working very close with the Pennsylvania State Police to get a certification.
Yeah, for the next job,
That was not, I understand, and that's not, I'm just saying that's why, unfortunately, he was trying to get this done, so he was able to do it on his own, but we will assist as much as we can.
But I'm not ignoring you, Sean, when I terminate, can't hear. Now, about the second-class township code, though, if we adopt that resolution, or that ordinance, there'll be a hearing here.
Yes.
And at least somebody will pay attention to that hearing. I mean, if they don't show, then we just go through our motion. There's no harm done.
Well, we would still have to, put our record in and make sure we meet the dangerous structure.
I realize that we will show. I'm talking about if he doesn't show, then that shouldn't
No,
buy
it
him
doesn't
more
stop
time.
us like
if he
anything
doesn't
else.
show.
It's a hearing that we will, for an ordinance, that we will have a public hearing, advertise it.
Is that going to be viewed negatively, though? I mean, I know that was something the insurance council brought up.
Well, that, maybe with the insurance council, but it is a route prescribed by law that we can take. We've always kind of been going after this route on a parallel track, and to Supervisor Cassiol's credit, like I said in the past, I mean, he's taken me to this site. He wanted it done for well over a year or so.
Right.
And,
Let's just do it and get it over.
yeah,
Well, now, let me just tell you the worst thing that could happen. If we have a hearing, they don't show, they don't challenge it, technically we'd have the right to go in and tear it down. And if we did that, he could then in turn, he'd probably sue us for the cost of it. But even if that's the case, we've been spending so much money on it, I don't care if we end up having to eat that cost.
So I understand, but I don't want you to prejudge the application or the ordinance, so we'd have to wait and see what the inside looks like. There's, with any time you're dealing with real estate, real property, there's constitutional considerations, and that's what the insurance company's mind.
We've gone through all the constitutional considerations for 10 years, and he's not going to let us get to an end point.
I understand, I'm just
He'll
saying.
never let us get to an end point if we depend on him to have to respond to anything.
I agree.
So I just want to ignore him and go through with it and let him be the one that has to react instead of us trying to react.
Once the hang-up's been, when Judge Costanza was there, she had a conflict and wouldn't let Bruce present certain things until she left the bench and went on to Court of Common Pleas, and that was about 4 or 5 months. And then, I agree, Tom, since Bruce does not have that certification, it makes sense, like you said, maybe we'll do it for the next one for Bruce. Let's move to the police to get the search warrant.
But I'm making a motion that in accordance with section 1533, that we schedule a hearing for an ordinance to require the removal of the Puchany property.
And I'll second that motion.
My only comment on the motion, Tom, is that I don't have the statute in front of me, and I'm not sure what comes first. If you can move for the hearing on that ordinance prior to getting the search warrant going inside.
We'll do them both at the same time. We'll get that search warrant. I mean, if he turns us down, then we'll advertise, we'll get rid of the hearing.
But if the search warrant is the prerequisite, I don't want you to prejudge and schedule a hearing.
Oh, no, I know we can't have the hearing without having our guy being inside. He'll be our key witness.
You understand, though, I don't want you to have at least I want the record to be clear that you're not scheduling the hearing in advance thinking that you're going to find the dangerous structure exists once we go inside.
I never said that. I said if our guy says it's not dangerous, then we'll honor that.
If it's presupposed on if, and the minutes and the record are clear, that you are not, you're presupposing in the event that you need a hearing, that you will schedule a